If you've turned on a radio or a television in the last 3 decades, you probably know the Cars for Kids jingle. It is an incredibly effective piece of marketing that built a widespread public assumption. You donate your old vehicle, and the proceeds go directly to helping general children in need. Relying on that simple premise, thousands of well-meaning people transferred actual physical value to the organization, handing over their keys under the belief they were contributing to a broad charitable cause. But the actual destination for those funds was highly specific. A court found that the vast majority of the money went to Orthodox Jewish programs in New York, New Jersey, and the Middle East, including a $16 million building in Israel. A California judge stepped in, ruling that the organization was violating the state's false advertising laws by misleading the public about where their donations were actually landing. The court took concrete action. The charity was ordered to stop airing its commercials in California, and they had to pay $250, the fair market value of the donated car, directly back to a donor who had been misled. This is the baseline of how our system is designed to function. When a private entity manipulates the rules to redirect resources, established legal guardrails step in to protect the public and enforce transparency. These protections work when the entity being checked is a private organization. It becomes much more complicated when the entity testing the legal system is the executive branch itself. Currently, President Donald Trump is in the final stages of negotiating an arrangement to resolve a massive legal maneuver initiated against his own government. Earlier this year, he filed lawsuits targeting federal agencies, suing the IRS over leaked tax records, and filing claims against the Department of Justice over their past investigations in him. The scale of this legal pressure is immense. The combined claims against the government amount to roughly $10 billion. Now, a settlement is on the table. The president is expected to drop these massive lawsuits in exchange for the creation of a $1.7 billion fund. Because this payout is structured as a legal settlement, the $1.7 billion can be moved without the standard congressional debates or appropriations that govern nearly every other form of federal spending. To receive and manage that $1.7 billion settlement, the agreement proposes an entirely new structural vehicle, the so-called Truth and Justice Commission. Once funds reach the commission, they pay the president's political allies, including January 6th rioters. Unlike standard funds, this commission has no requirement to disclose its internal procedures. Finally, the president can remove any member running the fund at any time, without cause. These specific rules, total secrecy in spending, combined with the president's power to fire the decision-makers at will, effectively remove the traditional checks that separate public funds from personal political interests. So if a state judge can easily halt a misleading car donation jingle, why doesn't a federal judge just step in and block this billion-dollar redirection of public resources? The federal judge overseeing the case has raised a major constitutional concern, questioning how the legal system is supposed to function when the plaintiff bringing the lawsuit and the defendant answering it are the exact same person. American law relies heavily on adversarial precedent. It is built on the requirement that two distinct opposing sides fight their case in court, allowing a judge to evaluate the merits of each. A sitting president suing his own executive agencies has no historical equivalent. Without a previous ruling to lean on, the judge faces a vacuum where the standard rules for blocking a settlement don't exist yet. The false advertising laws successfully caught up with Cars for Kids because the rules were well established and applied to a clear external violator. America's legal firewalls are only as strong as the precedents that uphold them. When a single executive authority occupies both sides of the courtroom, those firewalls collapse, leaving public resources entirely vulnerable.